morning, my lords. I appear for the Secretary of State, leading Miss Wakeman, and Miss Nike and Miss Actor represent Mr. Daci.
Good. I'm really embarrassed by this. It's not the first time I've asked you this. Smythe or Smith?
Smythe, my lord.
Thought so, but I better ask. Yeah.
Thank you, my lord. Housekeeping.
Yes.
Bundles.
Yes.
Dare I say the word bundles? Your lordship should have a core and supplementary bundle.
Yep.
And then the core bundle, which was also the core authorities bundle in Chowdhury.
Yes, I thought that had been replaced.
There's a supplementary Daci specific bundle.
Yep.
Of authorities, but your lordships also need the core authorities bundle.
Okay, so let me just be quite clear. So I've certainly got the core and the supplementary authorities. I've got the joint core.
That's the right one.
For both. And then I have got Daci supplementary authorities bundle. And then I've got a third one called respondent second supplementary. Well, that's from the respondent.
Well, it is, but we added a couple of bits at the end. Essentially, that's about the history.
Yes.
I will, in my submissions, do a very light touch recap on the legislative history, and we added 4 bits to the end of that bundle, and then Miss Nike will deal with that in her submissions insofar as she needs to.
Very well. Well, thank you. I've got fed up, and I'm sure those behind you have saying about late bundles, but we've got everything we need now.
Well, I'm glad to hear that, my lord, and I apologise sincerely for any lateness in this case. The order of my submissions is as follows. I'll cover things in 4 parts. So first, I will recap briefly on the Secretary of State's position as it was advanced in the Chowdhury case, and then where we are in terms of issues in this case. And then second, I will, as I've just said, touch very briefly on the legislative history to section 40, and then I'll deal with one other legal point there, again very briefly, which is the role of Article 8 in deprivation cases. Then I will turn to the facts of this case for the purposes of my grounds of appeal, and then fourth, I'll turn to the Upper Tribunal's decision and why we say our grounds of appeal are well founded. If the court is content, I've discussed with Miss Nike and we've agreed it would make sense for me to respond to her respondent's notice points after she's actually made them.
That's always more logical. Sometimes it doesn't work because the issues are so muddled up together, but I think they're sufficiently self-contained here, so let's do that.
I'm very grateful. So with that, could I start then by recapping on the Secretary of State's position? And I'm mindful that the court has been steeped in section 40, but could I just invite the court, please, to turn up section 40 now so that we can refocus on the fraud provision?
Yes.
So that's tab 1 of the core authorities bundle.
Yeah.
This is the current version, and as the court is now very well aware, section 42 is that the Secretary of State may deprive a person of their citizenship if the Secretary of State is satisfied that deprivation is conducive to the public good. So there it's a discretion may, and the Secretary of State has to be satisfied that deprivation is conducive to the public good. And then 3, similar in the same in those 2 respects, the Secretary of State may, by order, deprive a person of citizenship status which results from registration or naturalisation if the Secretary of State is satisfied that the registration or naturalisation was obtained by means of fraud, false representation or concealment of a material fact. So pausing there, the position is that the person who has to be satisfied here is also the Secretary of State, and just as with section 42, the discretion is the Secretary of State's and not anybody else's. And then the only other point to make is section 44, which is a prohibition on making an order if it would leave the person stateless, does not apply in a fraud case.
You said you were just recapping the submissions from Chowdhury. The submission from Chowdhury was that A, B and C, although it was Secretary of State to be satisfied, the FTT had full powers to decide whether on the balance of probability it had been proved.
Correct, my lord. So at that point, could I just perhaps invite the court to turn up paragraph 35 of our replacement skeleton, which captures what we say the three issues are and how we say that the court should approach them. So I'm imagining the court has the replacement skeleton loose.
Yeah.
You're imagining correctly, yeah.
I'm grateful. So paragraph 35 on page 9, we just summarise the position that we set out in Chowdhury, which is that the correct approach to an appeal against the section 43 decision is as follows. So it involves three questions. So the first question is whether, as a matter of past fact, there has been fraud, false representation or concealment of a material fact. And as the court knows, the Secretary of State accepts that the tribunal has a fact-finding function in that respect. Second, there's the question as to whether citizenship was obtained by means of that fraud, and that is, of course, part of the statutory language. And under section 43, it's the Secretary of State who needs to be satisfied as to that matter. So as in Chowdhury, we say that that conclusion in this case is subject to challenge on public law grounds only. In a moment, I'll say why that actually doesn't matter in this case, because it's all critical.
You've said it in your certain, but you don't say it again. Yep. Sorry,
Yes.
that came out badly.
I'll do my best not to.
No. I not
No, my lord, I'm grateful. And then the third question is whether the discretion to deprive should be exercised. And of course, we say there that's public law grounds only. So, dealing then briefly with Mr. Daci and why the conditions are satisfied in this case. The first question, well, there was fraud and that was admitted. There's no doubt about that. He lied. He said in particular that he was a national of Kosovo when he was not. And he also lied about his name and his age. But the core lie is, of course, the lie that he's a nationality that he isn't, which is what enables him to claim refugee status. So the first question we say is simple. As to the second question, why was the citizenship obtained by fraud? I'll show the court when I come to it the two reasons given in the decision letter. But essentially there are two freestanding reasons that the Secretary of State advances in this case on that causation question. The first is because as a result of his lie, he was granted indefinite leave to remain as a refugee. He was not entitled to be granted indefinite leave to remain as a refugee because he didn't qualify for it. As a result, he was able to meet the residence requirement for naturalisation. So that's the first independent reason. The second reason, which is connected but again stands on its own, is that if the Secretary of State had known the truth about the fact that he had advanced and maintained a false asylum claim, his application would have been refused on character grounds.
And the key thing is probably maintained because he first advanced it at a time when he was under 18.
Precisely, my lord. But I'll take the court briefly to the contemporaneous documents which show that it was maintained and maintained again. Now, had he told the truth at the time of his citizenship application, and had the Secretary of State said, as she says she clearly would have done, well, you've got bad character, you've made up an asylum claim, and refused his application on that basis, he could only have challenged that at the time on judicial review. And that's the point that Mr. Blundell made in Chowdhury. It's what we've described as the mirror point in Chowdhury, which is effectively, had he told the truth, he would have been limited to a judicial review challenge of that decision on good character grounds. So that...
Because it's not an immigration decision, and therefore you're not within Section 82.
Precisely, yes. And we've included some cases in the core bundle, and they're referred to in our skeleton, which shows that it's a high standard to defeat a decision of the Secretary of State that a person isn't of good character. So I won't repeat those, but they're in our skeleton argument. The court, I can give the paragraph numbers. It's paragraph 25 to 28. And then the final issue, the third issue, we say, of course, that the Upper Tribunal erred in law when deciding that the Secretary of State's exercise of discretion was unlawful, and I'll deal with that when I deal with my grounds. So where does that leave us then in terms of the issues? We say that the Upper Tribunal's decision is clearly wrong, and I don't need to turn them up now, but our grounds are at tab 2 of the core bundle. For that reason, we say that its decision needs to be set aside, and in fact can be remade by this court dismissing Mr. Daci's appeal, unless Miss Knight succeeds on her respondent's notice point. Now, and to summarise what we say on the respondent's notice point, we say there isn't really an issue about Begum in this case because there was no issue of fact, and whatever standard applies on the causation issue, we say Mr. Daci must fail, and I'll deal with that when I'm showing the court the decision letter. Finally, I don't...
But I thought on that, anyway, you had a procedural point, which is that...
I do, yes.
Yes, sorry.
Yes.
That's actually what I thought you were referring to earlier.
It's right, we've said that that hasn't been challenged by respondent's notice in any event, because the Upper Tribunal decided that the First-tier Tribunal had erred on the causation question.
Yeah.
And there's no challenge there, but to the extent that the point is raised and I need to address it, that's our answer to it.
Okay.
And then, so far as the discretion question is concerned, I don't know if Miss Nike is saying that the tribunal should exercise the discretion for itself, but if so, we say that's clearly wrong. It was accepted by Mr. Malik that that's wrong. This court in Shitey, Overton, expressed the view that it was wrong, and we submit it's clearly wrong. So I'm not proposing to say anything about Begum. The court will be pleased to hear at this stage. I'll deal with it in reply to Miss Nike if I need to.
Yep.
The court has Mr. Blundell's submissions. And then so far as Article 8 is concerned, we accept, as the court will have seen, that the Upper Tribunal didn't address the Article 8 claim, but we submit that it's very difficult to see how Mr. Daci could possibly succeed on Article 8. But to the extent that the court considers he might, then that issue would need to be remitted.
Yeah, well, we'll resist the temptation to debate that with you now, so let's hear how it's put by Ms. Nike.
So a couple of sort of mop-up points before I get into the two legal points I was going to make. The first is we don't oppose Miss Nike's amendments in principle to her respondent's notice. We've had a chance to answer them and we've done so in our skeleton. The second point is just to deal with a question that has arisen yesterday, although I think has been addressed in the Collicatch hearing, which is about the process that is followed in a fraud case. So the court will have seen here that what happened is that a letter was written offering an opportunity to make representations. Then the Secretary of State makes her decision, but she does not make a deprivation order in a fraud case at that stage. That is still the practice now.
So the practice as identified in Daci still applies in 3 cases?
Yes, it does.
Yeah.
So the deprivation order isn't made until after an appeal is dismissed. And the difference between this situation and a section 42 situation is that the statelessness provision doesn't apply. So all of the matters that the court heard about yesterday from the parties in that respect aren't raised here. So that's the process in a fraud case to cover that off.
Before you leave that point, can I just ask, and it's obviously as all the cases appeals slightly raise the same grounds or overlapping grounds, the distinction in the statute between 43 and 42 and statelessness, does that derive from the convention?
Yes, it does, and I forget its precise name, but I'm sure Miss Wakeman will tell me, and then I can give the court. But essentially, yes, the relevant convention says that doesn't apply in a fraud case,
Right.
which is the reason for the difference in the domestic legislation.
You're being helped.
It's helped very efficiently, as always with Miss Wakeman, a convention on the reduction of statelessness. Article 8. We can provide this to the court if that would help.
I think it'd be no harm at having it in case if we do want to refer to it, we have it to be accurate. But yes, well, tell us now what it says.
It says a contracting state shall not deprive a person of its nationality if such deprivation would render him stateless, but notwithstanding the provisions of paragraph 1 of this article, a person may be deprived of the nationality of a contracting state. And then limb A isn't relevant. Limb B says where the nationality has been obtained by misrepresentation or fraud. We'll ask our clerks to bring some copies at lunchtime.
Terrific, thank you.
Your lordships were missing having additional pages handed up, I sense.
No, we're used to it by now, and if we ask for them, we can't complain.
So with that, can I move on to the second section of my submission, which is to deal with 2 legal points only. The first is to touch on the history of the legislative provisions, and the second is to briefly cover Article 8. So turning then first to the history, that's the second supplementary authorities bundle, which should have 23 tabs, no, 24 tabs in it. So we're very grateful to Miss Knight and Miss Actor for preparing that bundle. The only reason it wasn't agreed immediately was because we hadn't had a chance to review it and see if anything needed to be added.
Well, we're grateful to everybody, thank you.
So, just for the court's awareness and interest, tab 21, which the Secretary of State added, is the 1914 Act. I won't spend long on it, but if the court turns to the second page, section 7 of that Act, this is the old version of section 40. So section 7.1 is the power to revoke. And then would the court just like to read sections 7.3 and 7.4?
Yes, interesting.
So that's the system of inquiry. We weren't able to see if that system existed any earlier than 1914, but certainly the system of inquiry was in place from at least 1914 and continued, as I'll show the court now, until 2003, albeit not in precisely the same form. So then, just for the court to note, we needn't turn to it in detail. Section 20 of the 1942 Act is at tab 22. And 22 is the power, and 27 is the inquiry provision. tab
Where's the, you say 1942 Act?
1948.
Page 48 Act.
So it
yes, that
starts
sounds-
at tab 22, and
I
you've
have it.
only included section 20. So again, the inquiry provision there at 20 sub 7.
Yeah.
And then the next development is the 1981 Act, and the court has an early version, not the earliest, but it doesn't matter. The earliest version of an early version, I'm sorry, of section 40 is at tab 10 of this bundle. Now, section 41.
Says it's the earliest version, doesn't it? It's version 1 of 6. But
Yes, but I'm not sure Westlaw goes all the way back to the
Yes, I
original.
see.
But
it doesn't matter.
But it doesn't matter. What it shows is section 47. The inquiry system is still alive and well.
This was the system that was considered in Chahal, is that right?
Yes,
And that was the reason for the change.
Actually, I'm not sure. I would need to check the answer to that. We'll check that at our end.
Because if you read Raymond, there's a sort of cryptic reference in Lord Hoffman's judgment to Chahal and the inquiry not being sufficiently independent to satisfy the European Court of Human Rights.
Yes, can we check that
Of
point
course,
over lunch?
yeah.
I'm very
And
grateful.
any assistance is very gratefully received.
Thank you, my lord. So that section 47 and then section 48 says the Secretary of State may make rules for the practice and procedure to be followed in connection with references under subsection 7 to a committee of inquiry. We have put those at tab 23 of the bundle, the rules.
So where's the rules bit?
Tab 23 of this bundle.
Referred to in 40 sub 8.
Yes, exactly.
Oh, 8, sorry. Thank you.
Yes, sorry. So just to note, for example, at Rule 4, which is on page 146, the committee shall give to each party at the inquiry an opportunity to address the committee to give evidence to call witnesses. And 2, the committee may receive oral, documentary or other evidence of any fact which appears to the committee to be relevant to the inquiry, notwithstanding that such evidence would be inadmissible in a court of law. So in terms of the Secretary of State's concession in Chowdhury in relation to the fact-finding function, one can see that certainly in the rules, although we don't know how these rules were applied in practice and we haven't been able to find that out, but the rules themselves provided for a power to receive evidence. And there are specific rules about deprivation. So that's why we've included those. And then the next significant development is, of course, the introduction of Section 40A by the 2002 Act, the Nationality, Immigration and Asylum Act 2002, and the inserting provision can be found at tab 2 of this bundle. So if the court turns to the inserted section 40A, it now introduces an appeal to an adjudicator. So from this point onwards, the inquiry system has gone. The other point we would make.
One moment, sorry. So what did the previous section 40? Well, that's what we've got.
So it will be the version in force up to the 1st of April 2023, which is at section 40. maybe at tab 10.
That's the original.
I'm not sure that we've got the one immediately prior. We've got the section 40As, but we haven't got all the iterations of section 40, but we can provide those.
Well, it doesn't matter. I was just seeing. So as I had obviously inferred, 40 sub 5 is new. I mean, the whole structure of 40 is different.
Yes.
But that some of those changes may only be structural rather than substantive. But 45 sub 5 is substantively new, because the role of what it was done, the procedure for which it provided was previously supplied by the inquiry system.
Exactly. Yes. That was
Not the procedure, but
The-
the purpose
yes.
of allowing
exactly.
independent investigation.
Yes, and then that system goes in because of the new section 40A, which is inserted
Yes.
as per tab 2. And what the court will see from that original section 40A is that it's a bare right of appeal, and it always has been, in the sense that there has never been a ground of appeal in section 40A. So one of
You
the
say it's a bare right of appeal. You mean there is no guidance as to the nature of the appeal?
there's no ground of appeal specified.
Yes, I see what you mean. Yes, sorry.
And the adjudicator is effectively the equivalent to the FTT, and the Immigration Appeal Tribunal equals the Upper Tribunal.
Yes, so the system was changed, but substantively there isn't a huge amount of difference. But yes, that's why it refers to the old system there. Now, what the court will also see is that section 40A has never applied the grounds of appeal, which used to be in section 84 of the 2002 Act. So as the court is probably aware, that there, before 2014, there was a right of an appeal against an immigration decision, and there were lots of different immigration decisions. And one of the grounds of appeal in section 84 was that a discretion conferred by the rules could have been exercised differently. I'm paraphrasing, but
Yeah, should have been exercised differently. Yeah.
yes, and that has never been a ground of appeal in a section 40A case.
So it's a completely different legislative history or stream.
Yes, it's always been, in terms of grounds of appeal and basis of allowing appeal, it has always been different from the system of appeals against immigration decisions under the 2002 Act. The only then point to mention is that there was at one stage a application of section 87. So if the court turns to the version of section 40A, which is at tab 8, and this is from the 4th of April 2005, what the court will see is that there's still no application of section 82 or section 84, but there is a limited reference to section 87, successful appeal direction. So what it says is section 87 applies, and then it specifies the purpose for which that direction can be given, for which purpose the direction may in particular provide for an order under section 40 to be treated as having had no effect. So what that didn't do, we say, is import the sort of grounds that appeared in section 84. It simply permits the tribunal to give a limited direction that an order is to be treated as having had no effect.
And that was enforced for only a year, was it?
No, it continues on. The reference to section 87 continues until the 2014 Act changes.
Yes, I see.
So, and as I've just said, the 2014 Act comes along, and this is remarked upon in Begum, and takes away appeal rights, and effectively what it says is you can appeal on human rights grounds or asylum grounds and so on, and the court will have seen that in other cases. So when that system is introduced, we then get the version of 40A, which is at tab.
So I can't remember exactly how Paul Reed puts it, but in a sense, reference to the 2014 Act is a bit of a red herring as regards naturalisation deprivation, or sorry, citizenship deprivation, because that had never been part of that scheme,
Yes, certainly.
apart from this tangential reference section 87.
Yes, limited provisions of the 2002 Act apply, but certainly the core provisions, which we would say are section 82, section 84, section 86, which are grounds of appeal and basis on which an appeal can be allowed, are not there and have never been there. And obviously, the direction which the tribunal can give is not greater than the jurisdiction which it has to decide the appeal in the first place. So the version of section 48 after the 2014 Act is at tab 4, and at that point the reference to section 87 is no longer there.
Sorry, tab 4.
Tab 4. And the version immediately preceding that is at tab 5.
Hang on.
So tab 4 is the post-2014 Act version.
Yes, I see. So basically the only difference is that 3A has come out.
Yes. But the version immediately preceding it is at tab 5.
Yes, that's how I see.
Yes. So that's all I was proposing to say about the history, but it does at least give a flavour of how things used to work with the inquiry system and how they've changed in legislative terms.
Well, thank you. It's been extremely economical and helpful.
So the only other point I wanted to make on the law, and I can take this briefly, is Article 8 and deprivation.
Yes.
Now, I can take this more slowly if it would assist the court. I can certainly tell the court where the authorities are, or I can show the court the authorities, but the position in a nutshell is this. 1, there is no convention right to citizenship. 2, the Strasbourg court asks itself whether deprivation is arbitrary. And then it looks at the consequences for the applicant, but that is the consequences of the deprivation only, not a more proleptic analysis.
I'm being slow. Why is your second proposition, why is Strasbourg even looking at this if there's no convention right to citizenship?
Yes.
Would one be clearer if one said no convention right to citizenship as such?
Yes. Perhaps it would be better to use the authorities rather than my summary. So perhaps we could first turn up Usmanov, which is in the supplementary authorities bundle at tab 10. It's not sidelined, but tab 10, page 318. Could I just invite the court?
Just give me one moment.
So this is the supplementary
Authorities
not
bundle.
Second supplementary.
The second supplementary is about the history, and I've certainly finished with that for now.
Thank you.
So this is the supplementary Daci specific bundle, tab 10, Usmanov. And the passage I'd like the court to read is at page 318, paragraphs 53 and 54. And Honourable Justice Underhill has it absolutely correct. The right to citizenship is not as such guaranteed.
Yeah.
So it's arbitrary rather than proportionate. Now, this
You're
formulation.
emphasising arbitrary rather than proportionate. I don't obviously want to protect all the authorities on that, but just broadly, is that clearly recognised in the Strasbourg case law as a different test rather than simply some interchangeability of labels?
Paragraph 54 spells out what arbitrariness means.
And you say if one reads that, one can
Yes,
see it's not the
it's
same as
different.
proportionality.
And indeed, that's the way the domestic courts have understood it as
Yeah.
well.
It's really to do with process in that sense.
Yes. Now,
And of
that
course, yeah.
the court may recall having read in Begum and for the court's noted in paragraph 64 the reference to arbitrary. We can turn that up now if that would assist.
Well, why not?
Why not? Exactly.
We are.
So, we're having fun.
It's we feel we've read Begum a dozen times, but reading it for different points. So
core authorities, tab 11,
yeah.
paragraph 64, and this is helpful in that Lord Reid talks about the requirements in the context of immigration control. So the passage starts on page 249, paragraph 64, recalling perhaps before we read it that Begum concerned not just a deprivation decision but a refusal of entry clearance. And a refusal of entry clearance would be immigration control. So that's why the court is talking about both. So paragraph 64.
Well, just 1 minute to make a note of that. Yep.
So that's why, first of all, at A on page 250, there's a reference to the position as it is in immigration control situations. And then at C, Lord Reid says this: a more limited approach has been adopted in cases concerned with deprivation of citizenship.
Yep.
And then he says specifically whether the revocation was arbitrary, not whether it was proportionate.
Yes. Oh, I agree. That's so he doesn't refer to as Marnoff, but he refers to the same
Exactly.
authorities as Marnoff refers to.
Yes. Yep. Now, the other cases on Article 8, I believe the court looked at Aziz yesterday, which is a judgment of law.
We didn't actually look at it. We looked at the summary of it. We haven't got Aziz itself.
Ah, well, we have it now.
Yes.
So it is at tab, it's in the supplementary authorities at tab 7. Page 208. And this is deprivation of citizenship following what are known as the Rochdale grooming cases.
Yeah.
So for the court's note, we don't need to go to them. The facts are at paragraphs 1 and 2, and then at paragraph 6 onwards.
Yeah.
And then what happens is the paragraphs 15 to 16, the first tier, this is page 214, the first tier in those cases finds that depriving the appellants of their citizenship wouldn't prevent them continuing their relationship with their family, wouldn't have any significant effect on the interests of their children, and the first tier says what it says at the end of paragraph 15. And then the first tier goes on to see whether or not there'd be a breach of Article 8 rights if the appellant were deported after deprivation. And this is really what the nub of Lord Justice Sale's judgment is about, and it's paragraph 26. We've sidelined the full passage, but the court need only read now paragraphs 26 and 27. And I'm sorry, the first few lines of paragraph 28 as well.
Is that worth reading the whole of 28, I think?
Yes, by all means. It is. We've sidelined the whole thing. It's all. It's fair to
Yes,
say.
but it is essentially skim reading, at least down to 29, because it covers not only the situation where deprivation would, as it were, in the abstract, open the door to deportation, which is 20, but it says even if it's been done primarily in order to move to deportation, which sometimes it is, sometimes it isn't. Even then, it's better to keep the two separate.
Yes, and there'll be limited classes of case in your lordship's second category where it might be relevant to look. Certainly not this case.
Yes,
but
it's
in
not
some,
entirely clear to me actually what that limited class of.
it's dealt with at paragraph 30.
Yes.
So it's where the Secretary of State's reasoning for the deprivation. It's in that specific type of case where the Secretary of State says, I'm depriving you because I want to deport you. In such a case, likely to be inappropriate, but the individual could say, well, I'm not going to be able to be deported, and therefore the reasoning is undermined accordingly.
Well, I see that, but conceptually that's right. It's hard to conceive of a case, well, certainly of a 43 case, where it wouldn't be justified, subject to any discretionary factors, it wouldn't be justified to remove citizenship simply because it was obtained by a lie, irrespective of whether you were going to deport subsequently, and many cases are of that kind.
Yes, and of course, as Lord Justice Sale says, there will be a right of appeal, and all of that can be canvassed.
Well,
at
that's
stage.
right, yes.
So
in a sense, I'm not entirely sure how the exceptional cases would arise, but that's what he says. So
yes, well, certainly to the extent that they do arise, we would say they don't arise here.
no.
This is absolutely no proleptic analysis permissible. So that's Aziz. The only other case, and since we're going through the cases, the court may as well just look it up. Is in the supplementary bundle, which is the same bundle that Aziz is in. The court has R3 at tab 12. Now this is a deprivation case, but not a 43 deprivation case. There is a short passage in Lady Justice Elizabeth Lane's judgment which summarises the position on Article 8, again pointing out its arbitrariness. So that's tab 12, 383, paragraph 107, and we've sidelined it, but that's simply for completeness.
Sorry, paragraph
107.
Thank you very much. R3 isn't one of the ones going to the Supreme Court. is
No,
it?
I'm not. It's certainly not one of the ones that's been heard recently. That was U3 and E3.
Yeah.
So that's
Yeah.
That's all I was proposing to say on the law, which then takes me to the third part of my submissions, the facts of this case. The court has the facts in paragraph 6 to 13 of our replacement skeleton, which has got the page numbers in the bundle. But what I'm going to do is just show the court 5 documents in the supplementary bundle relating to the fraud. So this is the supplementary appeal bundle rather than authorities.
So you say the facts were at paragraphs.
Paragraph 6 to 13 of our replacement skeleton, which gives all the page numbers.
Thank you.
So the 5 documents I will show the court. The first is when he is an adult, and that's at tab 8. And that, we say, is the fraudulent application for a Home Office travel document.
Yep.
So tab 8, the key lie, we say, is on page 80, box 9. He asserts, I am a refugee. I cannot approach my own national authorities. Well, of course he could, because his national authorities weren't the Kosovan authorities. So that's a lie. And then section 12 of the form on page 82, the lie is accompanied by a signed declaration that it's true. So section 12, 4th bullet, signature and date. The information I've given is true to the best of my knowledge. The second document is the application form for naturalisation. Page 87, and I'm sorry.
Sorry, what date is this document?
The application form.
No, the previous one.
Oh, the previous one. It is the 10th of December 1999.
So trying to cross-reference it, that's your paragraph 9 then.
Yes.
So you are not taking us to what you've set out in paragraph 7 and 8.
No, it's
No,
there. But
that's fine.
yes,
No.
it's there, but I don't think I need to show the court. So the next, it's paragraph 10, following along in the skeleton argument, is the application for naturalisation. Page 87, false name at 1.4, false nationality at 1.8, false date of birth at 1.10, false country of birth at 1.12. And then on page 88, he repeats that his father is deceased, although, as the Home Office commented, it seems that he was actually alive. That's in the decision letter. And then page 93, question 4.11. So that question 4.11 is in a box which says you must disclose details of any activities which might be relevant to the question of whether you are a person of good character. See page 18 of the guide. And we'll come on to that in a moment. Have you engaged in any other activities which might be relevant to the question of whether you are a person of good character? No. Well, he'd falsely claimed asylum. And then the declaration, section 7, He couldn't have been in any doubt about how serious it was to lie, because he's told at the top of section 7 to give false information on this form knowingly or recklessly is a criminal offence, punishable with up to 3 months imprisonment or by a fine. And then, having read that, he declares that to the best of his knowledge and belief, the information given in this application is correct. Well, we've seen that it isn't. I know of no reason why I should not be granted British citizenship. I promise to inform the Home Secretary of any change in circumstances which may affect the accuracy of the information given while this application is being considered. So there's absolutely no doubt just how important it is to be honest in this form. And then box 7.2, I confirm that I've read and understood the guide, which I'll show the court in a moment. And then there's a signature but no date. Nothing turns on that. It's addressed in the decision letter because the Secretary of State notes the date that the various referees give and also the date that she receives it, but it's certainly signed. So the guide that he signs that says that he's read, which is the third document, is at tab 16. And at the top of that third paragraph, it says it's important that you take care in completing the form and in making sure that you satisfy the requirements for naturalisation. Over the page 174, bullet points in between the hole punches, third bullet, the legal requirements are that you are of good character. And then there's a section on good character on page 182. So that says to be of good character, you should have shown respect for the rights and freedoms of the UK, observed its laws and fulfilled your duties and obligations. And then 4.6, 3 paragraphs down, it says you must give details of all criminal convictions. These include road traffic offences, but not fixed penalty notices. So except he didn't have a criminal conviction, but it's quite clear just from that alone that the Secretary of State wants to know even about road traffic offences. There couldn't reasonably be any doubt, even just reading that section, that lying about an asylum claim is liable to make somebody not of good character. And then 183, 4.7 to 4.11, 3 paragraphs from the bottom, you must say whether you've been involved in anything which might indicate that you're not of good character. You must give information about any of these activities, no matter how long ago this was. Checks will be made in all cases, and your application may fail and your fee will not be fully refunded if you make an untruthful declaration. If you are in any doubt whether you've done something, or it's been alleged that you've done something which might lead us to think that you're not of good character, you should say so. And then over the page, finally, 184, there's a section warning somebody to read the section carefully. And it points out the penultimate paragraph, applications that fail generally do so because applicants don't tell us about offences and convictions. And we would add to that, and lying about asylum claims.
You may add that. Guidance
It's
doesn't.
not, no, but it's we say if you
that is one of the most common things, you expect it to be.
Well, I think at this point
Maybe it wasn't.
it may maybe not have been one of the most common things, but certainly there have been a number of these cases. But we submit it couldn't be any more clear. He's also been warned that giving false information is a criminal offence. Just the fourth document is the contemporaneous good character guidance, which the Secretary of State would have been applying had he told the truth at the date of his application. That's at tab 17. And 2.1, we would not consider applicants.
I don't have a tab 17.
Oh.
Perhaps I should. But is it before page 191?
It's page 191.
Yeah. Okay. For some reason the tab's been. That's fine.
So it says we would not consider applicants to be of good character if, for example, there was information on file to suggest, and then over the page at 192, they practice deceit, for example, in their dealings with the Home Office. And then there's some more detailed guidance on deception here at page 204, 6.2. So if deception's on a minor matter, not relevant to the decision, it may be overlooked. But clearly, lying about an asylum claim is relevant to the decision. And then an example is given of deliberate deception, making an application on the basis of a marriage which isn't genuine. And then the final contemporaneous document to show the court is at tab 10. And this is when the Secretary of State says that the truth emerges. This is the information she receives from the Albanian authorities. And then page 101. There is his true identity. An Albanian national has been registered. Mr. Daci, there's his correct date of birth, gives his father's name, gives his mother's name, and then says the subjects are registered as living in, and then Albania. The current family composition consists of the subject and wider family. So what then happens is at tab 11.
Sorry, just out of curiosity. This is a chat with the Albanian authorities. So how, but not with the authorities in Kosovo. I appreciate.
No, it comes from the Albanian authorities, and the decision letter explains how the Secretary of State comes to learn of it.
No, but why do the Albanian authorities know what's on the Kosovo birth register?
They don't. They know what's on their own birth register.
But there's a line.
Oh yes, I don't know. I don't know the answer to that. But somebody behind me may know the
matters.
answer.
I'm just puzzled. Okay.
Yes, they conducted checks. I'm being told, but where it says in bold, no national is registered, that the Albanian authorities have themselves done checks with the Kosovan authorities.
Oh, I see. Yes. Thank you. Exactly. It's in the preceding line.
It is, but it's not in bold.
No. I should be able to read stuff that isn't in bold. Okay, well that explains that.
So
right.
What then happens is there's a warning letter, which is at tab 11.
Yeah.
Sets out the information the Secretary of State has, just to be aware that what the Secretary of State asks for is informed by the fact that she knows that she has a discretion, because she says, this is on the next page, in order to reach a decision on this matter, the Secretary of State now requires you to provide the following information: response to the allegation, personal and family life, compassionate circumstances. Now that can only go to discretion. And then human rights.
And indeed personal and family life, can you agree?
Yes, I mean yes. Family ties in the UK. Yes, given the way that Article 8 is assessed. So Mr. Daci then makes representations. These are at tab 12. And just a few points to highlight in this letter. So this is dated the 14th of June 2021, page 109. And all of this is relevant because it goes ultimately to why the Upper Tribunal was wrong. 109, between the two hole punches, he says, I was advised by an interpreter to claim to be Kosovan. I was a minor and I followed the ill advice given by the interpreter. And then there's a section on background history, which effectively says a number of other people have done this. Page 112, it says, well, they weren't just, it's effectively justifying this. It says they weren't just economic migrants, there was chaos and instability in the country. And then it says in the next paragraph, some were advised by agents who brought them
Where
to,
are we on one?
I'm sorry, page 112. This is,
Which paragraph?
it's the middle, so it starts between the, there's a paragraph, it was in this context, third paragraph
Yes, I
down.
got that. Yeah, thank you.
And
It's
then
actually
the reference to falling for unscrupulous agents, and then it says they carried these false details even to their children, and therefore they too had to live with these consequences, although it was never their fault. So in other words, we've been the victim of somebody else advising us to do something. And then over the page, there's a reference to the Secretary of State's policy 113, that there was an exception for those who'd been in the UK for over 14 years. And then there is further material about being encouraged to conceal identity on page 114. So and then it says between the hole punches, consequently, even though almost individuals admitted at the earliest opportunity that what they'd done was wrong and unlawful, there's been a historic delay. Well, the Secretary of State says in this case it isn't really admitting it at the earliest opportunity to do so in 2021 when the Secretary of State confronts you with the evidence. The representations, and this is important because it says under representation, this is a case where the Secretary of State should exercise his discretion not to deprive our client of his citizenship, as to do so would be unfair and unreasonable due to the mitigating and compassionate circumstances of this case. Furthermore, it would amount to a breach of Article 8. So various then, I won't go through them, but there are 4 headings for these matters that are said to be relevant to the exercise of the Secretary of State's discretion.
Sorry, just before we leave that,
Yes.
that page, and just so the reference at page 113,
Yes.
the reference to the policy on 27th of February 2010, is that a correct reference, and has that policy been overtaken?
It has. It's not, I think it wasn't in the bundles. It's an older version of the policy, but there was, and this is dealt with in the Highsage case, which Miss Knight tells me I'm pronouncing incorrectly, but in the Highsage case in the Upper Tribunal, there was an argument advanced about this policy and why Mr. Highsage should have benefited
Yes.
from it, and that argument failed. But effectively, it was only a, yes, it's gone by the time this this appellant is deprived. And it isn't as such.
it would be useful. I mean, you don't have it at your fingertips behind you. Well, when was the policy?
I think it's covered in detail in Highsage, so we can
Exactly,
find
I'm
that
sure that's someone
information
can look it
quite
up, but,
quickly.
yeah.
Yes, but it wasn't an absolute exception in any event. One of the points that's made in Highsage is you're subject to the policy that applies at the decision at the time the decision
Of
in your
course,
case.
that's why it failed. Yes.
Yes, because you can't. What you can't do is say, "Oh well, if I'd been honest sooner, I might have benefited from this policy." Well, then you should have been honest sooner.
Yeah.
So that is the representation. So 4 points are made, and the Secretary of State. So these are the points that the representatives say are relevant to the exercise of the Secretary of State's discretion. Entering as a minor, 14-year rule, doctrine of nullity and excessive delay, and Article 8 is a different issue. Now, all of these points, I'll show the court, are dealt with in the decision letter. So
Yeah.
we are simply at a loss to understand what it was that the Upper Tribunal thought the Secretary of State didn't deal with. So that's a convenient point then to turn to the decision letter, which is at tab 10 of the core bundle. Now, it's important to go through this with some care, which is what we say the Upper Tribunal did not do. The starting point is that at paragraph 5, the Secretary of State quotes her own policy. And importantly there is the very last line, because what the Secretary of State is saying in that policy is, if the relevant facts, had they been known at the time the application for citizenship was considered, would have affected the decision to grant citizenship, so that's in effect the capturing the by means of test, it is appropriate to consider deprivation. So even if you meet the first and the second condition as we've described them in our formulation of the issues, deprivation will be considered. And then, and I don't need to take up time with this, there's a chronology of the fraud at paragraphs 8 to 15, and then paragraph 17 to 18 describes how the fraud came to be uncovered. So information received from another government department. And then paragraphs 19 to 24 summarise his representations, and then go on to deal with the representations. And the court will note that at paragraph 25, the Secretary of State specifically describes the representations which have been made as mitigation. In mitigation, you've raised the point that you were a minor. In other words, I'm considering this when I'm considering the exercise of my discretion. So the Secretary of State deals with...
Sorry to interrupt.
Yes.
You said mitigation, I couldn't find that.
Paragraph 25, page 76. In mitigation...
Thank you. Yeah.
So the Secretary of State deals with that at paragraphs 25 and 26. I don't need to ask the court to read that reasoning. Effectively what you've said is, well, you might have been a minor originally, but you haven't been since then, in a nutshell. So she deals with his mitigating argument that he was a minor. Paragraph 27, she deals with the argument that he was advised by an interpreter
Just
to
hang
provide...
on 1 second, sorry. I was just going to get the representations.
The representations, they're in the supplementary.
No, I've got them now. Yes, I mean, although we've got these 4 neat numbered particular points, they don't pick up all the points that are made in the narrative, in particular the point about the one you've just come to about the interpreter.
Yes.
So that's dealt with, even though it's not one of the 4
Secretary
points.
of State certainly deals with everything.
Yeah.
Yes. Your representatives, and I should say, just to trail something, I'm going to say on my grounds of appeal, even if she hadn't, that wouldn't mean the Upper Tribunal was right, that it was a material consideration, because the test there is Wednesbury, and I'll come on to that. But in any event, the Secretary of State deals with everything. So this is the point about being an interpreter. And in a nutshell, the Secretary of State says, well, it seems unlikely. We can't see why a professional would lie. But in any event, you haven't put the record straight yourself. So that's at paragraph 27. Paragraph 28, the point that the deception was a one-off event, and the Secretary of State says, well, we don't agree, raises a point about something that happened in 2005. But the second point is you maintained the initial fraud on your later applications and have continued to do so for over 20 years. So that's how the Secretary of State answers the point that it was a one-off fraud, effectively. And then paragraph 29, the suggestion was that the Secretary of State should actually have worked out in 2006 that Mr. Daci had been lying and dealt with it then. And the Secretary of State's answer to that is, in fairness, the Secretary of State says, well, we can't establish that your wife provided your genuine birth certificate, but we'll assume in your favour that she did. However, given that you didn't give this to the Home Office and given no referral was made regarding your case, the Secretary of State remained unaware of your genuine identity. So the Secretary of State is saying I couldn't have been expected to piece together, given the information you told me about yourself, that when your wife provided the correct details to match up that this was you. So that's why the Home Office was unaware, and it's obviously not an attractive argument to say that the Home Office should have somehow worked out his fraud despite him not coming clean. And then paragraphs 30 to 34.
We don't know, do we, what prompted the inquiries in Tirana?
I don't, but I can ask those instructing me if
Well,
we know.
again, it's not sure it's fundamental importance.
Paragraphs 30 to 34, there is a comprehensive rebuttal of the arguments on delay. The Secretary of State says, well, that there actually hasn't been any delay because we weren't aware until May 2020. Paragraph 32, if you'd wish to be considered for deprivation in place under the policy prior to August 2014, you should have told us about your fraud sooner than you did. The Secretary of State's taken action as soon as your deception became known. And then paragraph 33, we acted as
There
soon...
we got the date, by the way. The policy actually came to an end
yes.
in August 2014.
But I know Miss Nike and I and my leader in that case did a comprehensive search. It was painful, wasn't it, pulling out all the policies. So we can certainly give chapter and verse. And then again described as mitigation, the final mitigation. So all of this is going to the Secretary of State's discretion, all of it. It couldn't be relevant to anything else. The final mitigation relates to issues surrounding your rights under Article 8. Now, except Article 8 isn't mitigation as such, so that's not good wording in the decision letter. But what's clear is the Secretary of State's got in mind, these are your mitigating circumstances. Shall I exercise my discretion? So, and then paragraph 36 again quotes the guidance about considering deprivation. So again, Secretary of State's well aware there's a discretion here. And then summarises paragraphs 36 to paragraph 40 effectively summarise why the Secretary of State considers that the causation requirement is met. So that's basically our second issue. Could I just invite the court to read paragraphs 36 to paragraph 40 of the decision letter on that causation point?
Yes.
So that's why I said there were two discrete grounds. One, you got ILR because we believed you were a refugee. And two, in any event, if you told the truth, you would have been rejected on good character grounds. Now, the person that can obviously say whether or not he would have been rejected on character grounds is the Secretary of State, because she's the one that sets the bar on character and she's the one that applies her policy if somebody tells her the truth. So those are the two factors. Could I just again show the court reference to the word consider at the end of paragraph 37? So what the Secretary of State is doing is saying, well, the causation requirement is met and therefore deprivation should be considered in your case. So, and yet another example that the Secretary of State is considering in the rest of this letter, whether she should exercise her discretion to deprive. Now, either now or when we finish with the letter, I just, on this causation point, just want to show the court the shitey decision of this court, which basically deals, we say, with any argument about causation. I can do that now or I can do it in reply. The court's seen what I've had to say about it in the skeleton.
Well, why not do it now?
So, shitey is in the core authorities bundle at tab 17. So that's tab 17, page 383. Facts at paragraph 8, very similar to this case.
Paragraphs.
8, page
Thank you.
389, facts. My Lord Justice Dingemans was in this case. Paragraph 78 records a submission that I made in Shitey on behalf of the Secretary of State. In the Shitey case. In that case, reliance was being placed on an Upper Tribunal decision called Sleeman, which is a decision in an applicant's favour on a causation point. And this is what we said about that in Shitey on the causation issue. So could I just ask the court to read paragraph 78, which is my submissions in Shitey?
Yes.
So what we were submitting there is what we submit here, which is, well, one, you lied and you got ILR, and there are some cases where the lie won't be material. Take the fact of Sleeman, for example, but that's not your case. And second, there's a discrete ground for saying that you've obtained your citizenship by fraud, which is that you're not of good character, and that point wasn't taken in the Sleeman decision letter. And that was the argument we advanced there, and it's accepted by the court at paragraph 87. And that's it. Essentially, first, Sleeman's not decisive because it could be distinguished on the grounds given the Secretary of State's notice of appeal to the Upper Tribunal. So to the extent that any reliance is placed on Sleeman in this case, and I can deal with the judgment itself in reply, our answer is exactly the same as it was in the Shitey case. It just doesn't help on these facts. So turning back then to the decision letter, paragraph 41, again, could I just ask the court to read paragraph 41?
Yes.
So what that's saying is effectively, for these reasons in summary, I consider that I should exercise my discretion to deprive you of your citizenship. That's the reference to reasonable and proportionate, effectively. It seems that the reason we are in this court is because in paragraph 43, rather than saying, this is on the next page, that this is probably what the letter should have said. It's acknowledged that the decision to deprive on the grounds of fraud is at the Secretary of State's discretion. In making the decision to deprive you of citizenship, the Secretary of State has taken into account the previous factors, but the Secretary of State says following. That we say is it. And it's quite clear why the Secretary of State has exercised her discretion to deprive. Finally, the Secretary of State deals with Article 8 and Section 45. Paragraph 47 makes clear that in deciding whether deprivation action is appropriate, again, that could only go to the discretion I've taken into account section 55. And then paragraphs 48 to 49 deal with statelessness, and then paragraphs 50 to 55 deal with next steps, and those are relevant to any limbo argument. The Secretary of State says precisely what timetable she will follow. So paragraph 51, she says deprivation order will be made within 4 weeks of your appeal rights being exhausted or confirmation that you won't appeal. And then within 8 weeks, subject to any representations you may make, a further decision will be made either to remove you from the UK, commence deportation action or issue leave. So there is a period of 8 weeks only where this person doesn't know what their situation is. That's relevant to any Article 8 claim. And then again, paragraph 52, the Secretary of State summarises the public interest and again says, having weighed those effects, it's concluded that it's reasonable and proportionate to depriving of citizenship. Again, that's discretion because we've already seen that the conditions are satisfied, and then finally we get the information about the right of appeal. So
Just going back to the short section headed Article 8, that isn't a perfect title. It's actually about Article 8 insofar as it relies on the threat of deportation or the risk of deportation. Because it's really what those paragraphs simply say is we're only concerned with deprivation, we're not concerned with deportation.
yes, in
as
paragraph.
is.
Sorry, my lord.
No, I repeat it. I've got there.
Paragraphs 45 and 46 are saying, well, yes, you'll lose some entitlements purely by virtue of the loss of British citizenship, and that will impact on your identity, but that doesn't outweigh the public interest.
Yeah.
Can I just ask about section 47 in the letter?
Yes.
Which refers to the children
Yes.
and wife. In those circumstances, is that to the discretion or not?
We would say that's part of the consideration.
So in fact, I mean, you said 43 should be amended to say previous factors, but in fact it's previous and following.
Yes, yes. So I can take my grounds of appeal very quickly, having done all of that. I'm just going to start, and I hope I'm not teaching your lordship to suck eggs. I may well be, but just so that we have it, I just wanted to show the court the Friends of the Earth decision on relevant considerations or material considerations. So that is in the supplementary authorities bundle at tab 12. At tab 9.
He's thrown a decision, right? Or am I confusing it with another one?
It's tab 9 of the supplementary authorities.
Yeah.
So this is the Supreme Court in the Friends of the Earth case. Page 292 of the bundle, paragraphs 116 to 121 have been sidelined. I just want to show the court two passages here. So paragraph 117 is a passage from the Creed NZ case, which is often cited in this context. Could I just ask the court to read paragraph 117?
Mm-hmm.
So either the statute expressly or impliedly identifies considerations which are required to be taken into account, or there is a matter which is so obviously material to a decision on a particular project that anything short of direct consideration would not be in accordance with the Act. And then that is expanded upon at 119. What is the test for that third category? It's this. This is 119, 3 lines down. The test whether a consideration falling within the third category is so obviously material that it must be taken into account is the familiar Wednesbury irrationality test.
Well, I can't remember. We've been referred to this case a good deal, but it's largely in a, isn't it in a consultation context?
It's certainly, insofar as there's any, I can show the court. I'll answer that
Well,
question
I mean,
by showing.
but what worries me about applying to a case like this is in a case where you have set up a procedure whereby you have invited representations. Surely the test there must be, you must consider the representations made pursuant to your request and give reasons why you do not accept them when you don't, subject to a generous view that sometimes some representations may be so obviously immaterial or silly that you don't need to waste time on them.
So can I answer that
Yes.
with 2 points? The first is I'm about to show the court consideration of these principles in the conduciveness deprivation context. That's the first point. But the second point in answer to your lordship's question is this, that we would submit there is a difference between the law on relevant considerations and the law on procedural fairness. So well it may be that if somebody makes representations, the Secretary of State should take them into account. But given that the test for the third category of relevant or material considerations is Wednesbury, it can't be right that by making a representation about something, the person making the representation effectively makes that a relevant consideration for the purposes of the law on relevant considerations. I accept different for procedural fairness, but conceptually, we say that those two things are distinct. Now, the difficulty we have with the Upper Tribunal's decision, and it might be apparent from the breadth of my ground, is we really don't know what the Upper Tribunal meant. Did it have in mind the law on relevant considerations, or did it just use that phrase and mean procedural fairness? If it meant procedural fairness, what was unfair? Because the Secretary of State considered everything. But certainly, if that answers your lordship's question, we would say those two things are discrete as a matter of public law.
Very well.
So I promised just now that I would show the court a case in the deprivation context. That's B4, which is in the first authorities bundle. No, sorry, the supplementary authorities bundle at tab 14. Yes, there it is. So this is a judgment of Lord Justice Singh, and the key passage on relevant considerations.
Sorry, I've just got behind. Which bundle is it in?
It's the supplementary authorities bundle, tab 14.
Oh yes, yep.
And the passage on relevant considerations. So the facts.
This is in a conduciveness
This
case.
it's a conduciveness. The facts, the core fact is at paragraph 1 and paragraph 9. And this is a national security case. So paragraph 1
Yep.
court sees its conduciveness, and paragraph 9 is the reasons why. That there is a passage, a detailed description of the law in the judgment of Lord Justice Singh at paragraphs 36 to 46. Paragraph 37 captures the law on relevant considerations far better than I could.
Yeah.
And then paragraphs 40 to 41, the court perhaps doesn't need to read those now, but just in a bit more detail break down the law on the third category.
Sorry, say it again.
The passage at paragraphs 40 to 41 break down the law on that third category of relevant considerations, say that it's Wednesbury unreasonable.
So when you say that third category of relevant considerations, where are you referring to?
I mean the not the considerations which are identified by the statute as considerations to which regard must be had or must not be had, but rather considerations which the decision maker may have regard, and that's the third category from effectively the Creed NZ judgment. So what are relevant considerations? One, those identified in the statute.
Oh, I'm sorry, I must be reading. I thought you were taking us to ground 2, fairness.
No, I'm in ground 1.
Sorry.
Relevant considerations. Sorry, my lord, I'm going
it's my
too
fault.
fast. Yep. Ground 1, relevant considerations. So paragraph 37.
Yeah.
3 categories of consideration.
I thought you said 47. That's
I'm sorry.
no, okay, I'm
37.
with you now. Yep.
So
Yes, got it.
I'll let your lordship read paragraph 37.
Yes.
So, and then paragraphs 40 to 41 again set out that when you are looking at the third category, which is considerations to which the decision maker must have regard, the test is Wednesbury unreasonableness.
Here's one way of formulating it, that it's Wednesbury unreasonable to ignore representations which you've asked to be made when you've got a duty to give reasons.
Yes, although we would say that analytically would still be a procedural fairness argument.
Right. And does it really matter? The point is it's justiciable.
Yes, it's justiciable. So the argument would be, well, the decision was irrational because you ignored something, or I said
it's not procedurally fair not to deal with it.
Exactly, and we accept that in principle those arguments can be run, but we simply don't understand what really.
That's a different point.
Yes. So,
but I mean, to analyse the law and do that, we're in danger of looking at these as if they're statutory instruments rather than decisions on particular facts.
Yes, I think from our purposes we're just keen not to do any damage to the law on relevant considerations with this case. That's all.
Okay,
but
you're warning us off.
Certainly not.
Whichever way we do the decision, analysing it in ways that's inconsistent with Creed NZ.
Yes, I mean, from our perspective, looking at the decision of the Upper Tribunal, we simply weren't sure what actually the Upper Tribunal's decision was. It may have used the words relevant considerations, but not meant this line of case. We don't know. I can now turn up the Upper Tribunal decision, and I've effectively made my submissions, but I'll finish them by showing the court the Upper Tribunal's decision, and that is at tab 6 of the core bundle. So, paragraph 7, at the outset of the resumed hearing, I initiated a discussion with the reps as to the applicable legal framework. Both were agreed that I should follow the guidance set out in Chimmy. I should say that the Secretary of State now says yes, but subject to the concession that was made in Chowdhury. But we didn't say that at the time. And then paragraph
which, sorry to interrupt, but which to complete your submission is, which you say doesn't matter because it was common ground that there was a fraud in this.
Precisely, and your lordship will see that at paragraph 11. Now, it isn't actually, in fairness, it isn't clear from paragraph 11 whether that simply relates to the fraud or to the causation requirement. So I'm perfectly prepared to accept it was just to the question of fraud, but nothing matters for present purposes. The reference there, and we don't need to turn it up, is I think we can assume that that's only about fraud because the First-tier Tribunal erroneously decided that the causation requirement wasn't met, so that can only be about fraud in paragraph 11. And then paragraph 12, I don't know if Miss Knight will say that this inaccurately reflects the submissions that were made to the Upper Tribunal, but it does say at paragraph 12, both representatives were agreed that the core issues for me to determine were whether the respondent had exercised his discretion at all, and if so, whether that had been done lawfully with reference to public law principles. If the answer was no, the appeal would fall to be allowed on this basis and the matter would go alone, and the matter would go back to the respondent. Well, of course, Miss Knight now says it was an error, a legal error, not to have considered the Article 8 decision, but the tribunal appears to be saying, and Miss Knight may well say, the tribunal's got this wrong, but it's right that I show the court in the Upper Tribunal's decision what the tribunal seems to have thought was the agreed position. And then C, if the answer to A was yes, in other words, was there a lawful decision, whether the decision under appeal nonetheless breaches the appellant's right. So that's how the tribunal did things. And then we get the parties' submissions. Important to show paragraph 15. Mrs. Nolan is the Home Office presenting officer, and she says, in terms of the respondent's discretion, she submitted that it had been lawfully exercised. The respondent had been aware of relevant considerations, including the appellant's age. The issue of delay had been specifically referred to in the decision letter, and of course, I've shown the court that there were a lot of things considered in the decision letter. Certainly that the Home Office presenting officer is saying, well, the Secretary of State did exercise the discretion. And then paragraph 18, we get what Miss Actor, who was counsel below, said what the relevant considerations were at paragraph 18. She says, the appellant's age at relevant points in time, his length of residence, his overall family circumstances, his business, and what was considered in the respondent's guidance. Well, the Secretary of State has considered all of those things. And then the tribunal gives very short reasons. It simply says, paragraph 22 at the bottom of page 40, in my view, Miss Actor was right in her submission that the decision letter was concerned with the condition precedent issue up until 43. Well, we simply don't understand that because, as I've shown the court, it goes way beyond considering either the question of fraud or the question of causation. It goes into all sorts of things which could not possibly have had any bearing on either of those questions, not least because many of them post-date the fraud, for example, length of residence and so on, but they go into him being a minor, compassionate factors, all sorts of things. So that is simply wrong as a matter of fact in the tribunal's decision. When it says a number of factors had been set out, they all fed into the question of whether there had been deception and whether this had been causally linked. Well, I've shown the court that's just wrong. And then paragraph 23, it's only paragraph 43 which addresses the discrete issue of discretion. And that's the paragraph with the wrong reference to following, which should have been previous and following. That paragraph acknowledges the existence of discretion. The problem with it, and one which in my view is fatal to the lawfulness of the decision, is that there's no consideration of a variety of relevant factors which I'm satisfied were put before the respondent at that time. But what factors? Because they were all considered. And then paragraph 24 says you can't use the Article 8 assessment, but the Secretary of State didn't. The Secretary of State considered all the factors. And then the tribunal says at 25, it can't be said that if discretion had been lawfully exercised having regard to the variety of factors which were before the decision maker, the outcome would inevitably have been negative. Although a number of considerations clearly weighed against him, others might arguably be said to have carried not inconsiderable weight in his favour. But what? We simply don't know what, and we certainly agree with the comments that Lady Justice Andrews made when granting permission, which is that she'd read this decision 3 times and simply wasn't able to work out what it was that the Secretary of State didn't do.
Have we got?
It is in the bundle, yes.
Is it?
It's at tab. It's definitely here. Tab 5. Oh, in the supplementary bundle. Sorry, yes, not in this core bundle.
Sorry,
Supplementary.
I didn't look for it there. No, okay, that's helpful.
What Lady Justice Andrews says, and we agree, is that the decision letter has not been read as a whole. It's been construed like a statute, and an extremely restricted approach has been adopted. So, with that, my grounds of appeal, I say I've now made. I'll come to them momentarily. I just want to make a point on paragraph 18 to be clear. Our position is, for the purposes of the law on relevant considerations specifically, the factors in paragraph 18 are not factors which it would have been Wednesbury unreasonable for the Secretary of State not to consider. However, to the extent that anything was raised in correspondence, the Secretary of State dealt with it. So, insofar
Sorry,
as
the factors in
paragraph 18, which
Para
are
18.
Ms. Actors, the relevant considerations for the exercise of discretion had included. It doesn't appear that the case law was cited on relevant considerations, but certainly to be clear, we would not accept that the factors at paragraph 18, in the context of a decision to deprive citizenship obtained by fraud, that had the Secretary of State not considered these matters, it would be Wednesbury unreasonable for her not to do so, in terms purely of relevant considerations test.
But surely the first factor, age at the time that you've made the first representation, is plainly material. Even the Secretary of State engaged with it and said, well, my
Yes,
policy had
and-
changed. That would, I mean, no one would accept that any decision which failed to engage that could ever be lawful.
I accept that, whether or not for the purposes of the
The
statute.
second, the third, fourth, and
Yes.
things. But I mean, that's the trouble with sweeping submissions.
Yes, precisely. Yes, I mean, I have to. I think it's right to say that it would rather depend on the circumstances, because in a case where the person had made a lie at age 18 and had then applied for citizenship at age 40, having on 10 occasions represented their false identity, it might be said that their age was not a relevant consideration for those purposes.
well, there's
So-
a very, you might say it was a relevant consideration, but obviously didn't carry very much weight.
Yes, I mean, whether or not it's Wednesbury unreasonable not to consider it, the Secretary of State did anyway, so this is all academic. But
Right, that's rather. Well,
We're
I
having
understand the importance the Secretary of State attaches to this point of principle, but it's
there
not
we
really
are.
going to be what this case is about.
No. There we are, I'm getting overexcited. So with that, I'm going to shut up shortly. My grounds of appeal are at tab 2. Why was this decision wrong in law? The first ground is attacking the conclusion that the Secretary of State hadn't taken into account relevant considerations. And lim A, this is on page 14, is the tribunal didn't direct itself on the law on relevant considerations. We don't even really know if that was what it had in mind. Second, in any event, the Secretary of State did take into account a range of factors which could only have been relevant to the exercise of the discretion. So whatever law the tribunal had in mind, the Secretary of State didn't breach it. And then finally, we say failed to give proper decisions. This genuinely is a decision where the losing party cannot understand why they lost, because the Secretary of State would say, well, you've said I didn't take into account factors that could have made a difference. What are they? So that's why the reasons challenge. And then 2 and 3 really probably don't arise, but paragraph 2 is the tribunal said the decision's unlawful for failure to give reasons, but the Secretary of State gave a huge number of reasons. And then the final point is really a fallback point, and it doesn't arise, so I needn't say any more about that. So those are my submissions on our grounds.
Just hang on 1 second.
Unless I can assist the court further, those are the submissions on our grounds.
No, thank you. That's been extremely helpful. Yes, Ms. Knight.
Thank you very much, my lords. Can I just say in summary, the respondent's position, and I can appreciate that through our respondent's notice we make there's a variety of issues, but the primary contention is that the Upper Tribunal was correct in law in allowing the appellants, as he was then, appeal for the reasons he gave, and that he was correct to find that the Secretary of State had not properly directed herself both to the matters that were raised on invitation in the representations in her decision letter, when set against her own policy considerations, which were partially addressed in the decision letter, but not fully. And in particular, the relevance of the respondent's age at the material times, and my lords will have noticed that the reference from the Upper Tribunal there was to material times, not material time. And so, in those circumstances, in the way that the claim or the appeal was put to the Secretary of State, put to the First-tier Tribunal, put to the Upper Tribunal, that the Upper Tribunal is entitled and indeed correct to allow the appeal on the narrow framework on the applying the Chicheri-Begum public law principles.
So you say this is your primary. So your primary contention is not based on the respondent's notice points, but on simply saying upholding the tribunal's own reasoning.
If we succeed on that, then the Secretary of State's appeal falls away. But we also have to address the court on what would happen if this appeal were to be remitted. I apologise. If we are correct on that, then the Secretary of State appeal falls away, and then we await for a new decision. But the question, if there is a new decision, we don't know what the Secretary of State's position would be, which is that we've successfully appealed the decision to deprive. The question that arises in the first question that then arises in our respondent's notice, which is whether the tribunal should have gone on to look at the question of Article 8, and that was how we put it in our respondent's notice as it was originally put. And I hope you have that. That's in the supplement. I've got it loose, but I think the court will have it. And it was lodged in time, and then it was amended in the technically within the essential time to amend that. So, if we're correct, then the deprivation decision simply is overturned or back to the Secretary of State for her further consideration. Should the tribunal judge have gone on to consider the Article 8 grounds? We say that the tribunal judge should have done that, because we totally accept that, as Miss Smythe has just taken the tribunal to the court too, that the parties agreed that the Chimi approach should be adopted, which is determine the public law question first, and if you don't succeed on that point, then go further to look at Article 8. But there is in the circumstances now where the court is presented with a conflict between Chimi and Chicheri in terms of the approach of tribunals in this context, and given perhaps that there are many such appeals before the tribunals below, and indeed some of them end up in this court, that is a question which this court should determine. And my hearing Miss Smythe's submissions today, I understood her submission to be that she would, just make sure I've got that right, that she would agree that we accept that the tribunal didn't accept Article 8. Difficult on her submission to see how we could succeed. We say we have our factors and we can take the court to them, but it should be remitted to the tribunal for that determination. And the question that this court has to decide is, furthermore, given the conflict between Chicheri and Chimmy, is that Chimmy says, when determining Article 8, ignore all of the factors that go to discretion because you've just lost on those, which is and we say that can't possibly be correct. So there's a number of sort of cascading points, if I can say that in opening, which the court needs to be addressed or need to address. But I think I now understand it to be, just looking at the respondent's notice, I now understand that the Secretary of State accepts, as she should, that the decision in Aziz and indeed Daci and other decisions of this court mean that the tribunal, in determining Article 8, has to look at the reasonably foreseeable consequences of deprivation where Article 8 is engaged. And Article 8 is engaged in circumstances where deprivation and loss of status as a consequence has an impact on one's social identity and private life. But just for that limited question.
And not the deportation issue, which, if it ever arose, would be confronted later.
Indeed, and just one observation, just in opening on Aziz, of course, it was a 42 case, and the deprivation on the conducive grounds there was made with a view to effecting deportation. In these fraud cases, and obviously they're all different, but in this class, if I can put it in those terms, in these cases, the Secretary of State is silent on whether the respondent, in this case, will be removed, and she's silent on whether he will be granted any further period of leave. But what the decision letter must anticipate is that the respondent is someone who's left with insecure status for, as my Lord or Justice under the Vice President summarised it, the limbo point. And what the limbo point means is something that we would like to just consider a little further, although the court's obviously is aware.
So is the limbo point and the harsh immigration or the harsh sort of environment?
The limbo point, we say, is in summary, is a person is left on deprivation without any status at all. That may, for an unknown period of time, because although the Secretary of State says she will make a decision, if that decision is negative, and that's certainly reasonably foreseeable, we don't have to go on the merits of whether an appeal will be granted, then we have to look at how long any appeal might take to be effective. And we've got the skeleton argument in the First-tier Tribunal where we submitted it was 8 months or so, and there's no suggestion from the Secretary of State that isn't a correct period of time. So in circumstances where if the decision is to deprive and not to simultaneously make a grant of leave, because that's within the policy, that could happen, and indeed historically that did happen. There's now this sort of separate two-stage process, but it's quite clear in the policy, and I'll take the court to that in due course, that the decisions can be made simultaneously. It's provided for in the policy. So where the Secretary of State has decided not to do that, not to grant period of leave and create the limbo, and she says I'm well aware of the relevant factors, then we say those are matters that the court, the tribunal, when considering the Article 8 question, it's not an unlawful proleptic analysis. What it is looking at the impact on the individual. So he's unable to work, run a bank account, drive, he's a self-employed, runs a business, he supports his now 4 children, I think there were 3 at the time, and maybe 2 at the time of the original decision. Although his wife and children are British, his wife doesn't work, has never worked. And although we come to look at it, but Miss Smythe's skeleton refers to the decision in what I'm calling Upper Tribunal 3, that was on the particular facts of his case. And again, observing what my Lord Justice Underhill, the Vice President, said in Daci, it may be that it'll be an exceptional case to displace those factors, but all of that needs to be considered by the First-tier Tribunal, and that wasn't done. So if we're in agreement that the matter has to go back for that to happen, or the alternative is that either we succeed in our appeal on the Upper Tribunal, we wait for another decision, and then there's still the unresolved question of what role, if we have another appeal, if it's negative, what role the tribunal should perform.
Can we just focus on this?
Yes.
If the Secretary of State succeeds on the appeal,
Yes.
but you succeed on Respondent's Notice Ground 1,
Yes.
so that the judge should have decided the Article 8 point,
Yes.
are you saying that we can decide it, or are you saying let's go back?
No, we say that the Article 8 question should go back because there's been no
Okay, well,
relevant
that's fine.
findings of fact. And indeed, although evidence was called in the Upper Tribunal, and indeed my learned
Well, I mean, in a sense, that's all we need to know, isn't
Yes.
it? Unless well, you may still. I understood Miss Smythe to submit, though she didn't develop it, which is its respondent's notice point, that there was no chance of the Article 8 point succeeding. So we can decide it in her favour. You are presumably going to address us on that, but you're not saying that we can decide it in your favour.
No, we don't invite that.
Yeah, okay.
Because there's been no findings of fact. The judge heard the evidence, but he records it in summary, but he does, the Upper Tribunal judge, but he doesn't make any findings on the evidence because of his approach
No, quite.
following Chimi.
Quite. And we haven't got all the material
Indeed.
that he had. I mean, that's a difficulty that Smythe faces, which I didn't put to this
Yes,
stage,
we
because
Yes.
Smythe, you're nodding. You're not.
Yes,
Perhaps I did note. I thought I understood you to submit that we should decide the Article 8 point in your favour, but I didn't question you about it because I saw it as a respondent's notice point. Is that realistic?
It's fair to say that's a very ambitious submission, I would say.
Yes. Right.
Yes.
I'm going to interpret that as meaning you needn't.
So I'll take instructions over
Take
lunch
instru-
to
take-
see. I'll talk to those sitting behind me, and
It's not a question so much of our expressing one view on either side's favour about whether it's likely to succeed. It's just we don't have all the material in front of us.
yes, I accept
And
that.
he gave evidence. He was cross-examined, but we
Yes.
haven't been told what he said.
Yes.
So,
Yes.
I'm grateful for that indication. And
well,
it's
subject to Ms. Smythe not getting the instructions
yes,
which she anticipates, if I can go that far, I think you can assume that the respondent's notice point that point really doesn't arise, because I think Ms. Smythe accepts that Article 8 should have been considered, subject only to the point that Ms. Actor is said to have conceded it below, conceded that it needn't be dealt with.
well,
but-
yes. I mean, I think Miss Actor's position and the parties' positions were follow Chimi because it's the
Yes, but you're now saying that Chimi is clearly wrong.
yes.
Well, we will also consider it over lunch, but I think you needn't address us any more on that aspect. In a sense, you're only trailing it anyway.
Yes, indeed. And so
Yeah, okay.
I just wanted to open just have the respondent's notice open just so that I'm clear about where my submissions are going
Yes.
for the rest of before lunch and then beyond, because I'm going to respond to Secretary of State's submissions on the appeal first. But I just wanted to trail that if we say the judge should have considered and then allowed, but considered the Article 8 grounds, and that the reasonably foreseeable consequences needed to be addressed. And there's very clear authority per Laci as the Secretary of State's own decision letter.
Well, the reasonably foreseeable consequences other than deportation.
Other than deportation, yes, we don't need to.
Okay.
And that paragraph 3 of the respondent's notice therefore goes into that clash, if you like, between Chicheri and Chimi, which is what's the correct approach in law. And I will address the court on that, because it is a peculiarity. Chimi not only says do one and then do the other if you don't succeed on the first, but disregard all of the discretion factors when you get to Article 8, and we say that cannot be right. But I will come back to addressing the court on that. And then the final point, and maybe it may well be that we don't need to, this court will have to decide whether it wants to hear the submissions as to whether Begum is actually applicable in these Rule 43 cases, and that just goes to the submissions. I listened to the decision, to the hearing in Chowdhury, insofar as I could hear all of it, and the colloquy, I think we're calling it that, hearing yesterday. And I just wanted to be to make some brief submissions up in response to the Chowdhury structure of the decision making, which Miss Smythe adopts in relation to what the tribunal, what any tribunal should be doing in an appeal, because for the purpose of my case, and it may not be clear to the court as yet, because we've just received the Secretary of State skeleton 2 weeks ago, and it was a sort of lengthy document in response, which responded to our respondent's notice, and the Secretary of State's position, as the court has acknowledged in Chowdhury and now, has changed in the course of this appeal. She never advanced the case before the First-tier Tribunal or the Upper Tribunal.
Well, we are where we are. What are you saying about what your position
I
is?
just want to, so the position, I accept that the Secretary of State is the decision maker, and I accept because the condition precedent has to be satisfied. The question, and then the Secretary of State's position in Chowdhury was that the question of whether the condition precedent is made out is on a Wednesbury test for the public law grounds, and that then you get to discretion. But in this case, there's a particular question as to where the policy fits into that structure, because we know that Secretary of State's policy for minors, those who came and acquired their leave as a minor, she regards them as not complicit for the purpose of fraud, and that seems in my submission, and I'm taking this in this way because I know the court's heard a lot of argument already over the last couple of days. But the complicity question must be part of the condition precedent rather than the discretion question.
Well, I think that's.
Is that? Do we? Is that? I hadn't actually clearly understood, Miss.
I mean, if it helps to share what we understand the position to be, which is 43 is for the Secretary of State to decide whether there is fraud. Just keep it with that. But that when it comes to the FTT, the Secretary of State accepts that's a condition precedent which needs to be proved on the balance of probabilities. In many cases, it's common ground that there has been a fraud. And then thereafter, whether that condition precedent that led to the grant of citizenship is to be considered by reference to public law grounds. So you could only attack it on conventional judicial review grounds, and similarly for the exercise of the discretion.
So the condition precedent is like a precedent fact, effectively the fraud question, rather than obtained by also being a condition precedent, because that's in the view of the Secretary of State.
Yeah, that's the submission that was made.
Yes,
in
well, that's very helpful because so on the question of fraud, my lords will have seen, and Miss Smythe identified that what's been conceded in the claimant's case, and it was very fair of her to observe that just in her opening, was the fact of a fraud, and she took you through where it had been made. But the initial fraud was when he was a child and a child in care, and the Secretary of State's policy as to where complicity arises, and this was how the case was put to the first tier and the upper tier. It's not clearly recorded in the upper tier's decision, but this is how we have the skeletons, and we can show those if the court needs to see it. But the way the case was put on fraud was that the policy says if a child takes an active step to acquire, and uses the word acquire, ILR post 18, then they will be deemed complicit. But this appellant, respondent, didn't take an active step. When he was 18, he was just waiting for a decision on an asylum claim that he'd made. Admittedly, it was a fraudulent claim. And 71 days or 2 months after his 18th birthday, whilst he was still a child in care, the ILR as a refugee was granted. No active steps taken. And the policy says, what steps do you take?
What the Secretary of State relies on in this case, which you'll need to deal with, are the active steps thereafter, which is to applying for naturalisation, applying for the passport.
Well, yes, my lord, our response to that is that we don't, if we're right on the complicity question, we don't have to deal with those steps, because if you're a minor who requires ILR as a minor, or no other active steps, then the Secretary of State deems you're not complicit in the fraud and everything else falls away. She doesn't then go on all of the...
What about the false name afterwards?
In the Secretary of State's policy, and again, Miss Smythe
You can take us
she
to
can
the
correct me if I'm
policy.
wrong,
I
but
think
that's
you were trying to address a taxonomic question, which is under which head does the arguments you've just
Yes.
outlined, which obviously we're familiar with,
Yeah.
what does it fall? I'm not expressing any considered view, but I would have thought more naturally it falls under the discretion. You committed a fraud. The Secretary of State's policy is to overlook that fraud, subject to all the qualifications we may have to put to it, if it was committed when they were a minor. And that is a matter of policy and discretion.
Well,
But the basic requirement of the statute,
yeah.
it has been satisfied. That is to say that they committed a deception.
Well, so that comes to the question of when my Lord Justice Dingemans was asking Mr. Malik and Mr. Blundell, I think, in the Chowdhury case about, well, who's determining the question of concealment of a material fact, and the materiality question, is that a question of law or a question of fact?
Well, okay, but I'm not quite sure what you're trying to work out to what extent you need to. This is how we got onto all
Yes.
this. You need to address the Begum question.
Yes.
And the first question, whether a fraud was committed, it doesn't arise in this case because it's conceded. The second question, whether it was material, well, we'll have to hear you on that, but there's at least an argument that doesn't really arise here because it's not been challenged since the decision of the FTT was overturned. And so the real question is, the argument you want to run about him only being 17 and a half comes up in the context of the discretion. And on the discretion, the position taken by the Secretary of State is that that is governed by ordinary public law principles. We can't take a different decision from the Secretary of State, or rather the Upper Tribunal can't. So if you are going to raise that point under the head of the discretion, and you want to say that the test is not the one the Secretary of State says, but is actually we can just take a different view on the exercise of discretion, or rather the Upper Tribunal could have, you'll have to go into Begum. If you're content to deal with it as a matter of ordinary public law, then you won't have to go into Begum. I think I've summarised that.
I think that is fair. The only sort of gloss I put on that is that we say, and this was how the case was put to the first tier and the upper tier, was that the Secretary of State hadn't properly applied her own policy in determining the question of complicity.
Well, that's a perfectly straightforward public law challenge, and you
Yes.
can deal with it.
And whether that
Certainly, you can deal with this a public law point. Up to you whether you want to aim higher.
Yes,
But
well, I
at the
want
moment,
to-
I can't quite see why you would want to.
No,
but
well, I want to.
up to you.
Obviously, want to try to succeed in the appellant's appeal, so I want to aim where the target is most appropriate. But those,
Well-
I just wanted to foreshadow that that's how.
Well, can I
we-
summarise where I think we've got to? And
Yeah.
if we haven't, you must state it. You obviously want to run the argument you've just run.
Yes.
I know that. But you are content to run it as a public law challenge on the basis of departure from policy or any other typical public law ground you can think of, irrationality or unfairness.
Can I
But
just turn my back to
yes.
Yes, that is the way that we.
Well, okay,
would
that
be happy to-
that means we don't, I think, need to be addressed by you on Begum. And that's been a helpful ground clearing exercise.
Yes, okay, yeah, thank you very much. So first of all, we've now just come to responding to the way in which the Secretary of State's put her case and our skeleton argument. So And I just wanted, if I might, just to, because Miss Smythe took you to the history of the appeals, if it's useful, I could just wanted to make a couple of observations on the history of the appellate structure. So that the court has a complete picture of how the right of appeal came into being. And Mr. Smythe took you to the original versions of Section 40, and the critical thing was that prior to the 2002 Act, so if we look at the Section 40 as originally introduced, that's at tab 10 of, so I'm in second supplementary authorities bundle. At tab 10. So just usefully to see that the original version was the Secretary of State may by order deprive under 41, and then under section 3 there was a subsection 3 there was a question about that was a sort of conducive type ground, and then section 5 was and section 5 further dealt with non-conducive to the public good, and then the stateless exception, and then the manner of the inquiry was in subsection 7, which was the committee of inquiry. And I think my Lord Justice Dingemans asked me, was that the sort of reason for the Remen decision? But I just wanted to emphasise that in Remen, it wasn't concerned with deprivation of nationality, it was concerned with deportation on non-conducive grounds. And so, although that was what led to the creation of the 97 SIAC Act, it was looking at a different type of appeal, albeit that it was then sort of transposed, or some of those principles were adopted in the national security context for deprivation, but just as for a matter of strict accuracy.
I think SIAC followed the decision in Chahal,
Yes.
the Secretary of State's response to that.
That's right. And Remen was commenting, the observations of Lord
yeah.
Hoffman was commenting on that in terms of the institutional competence and the separation of powers point. So the decision, section 4 of the 2002 Act introduced the right of appeal. That's behind tab 2. And it also changed the structure of the of section 40. So it changed the structure to the one similar to what we have now, so the 43 structure. And I just again observed that safer that under 42, the non-conducive ground was there put in much higher terms, seriously prejudicial to the vital interests of the UK. So that was changed subsequently, and to the non-conducive position.
Sorry, which divide are you on?
Tab 2.
Thank you.
So the section 4 of the 2002 Act changed the structure of deprivation decisions. The 42 was the sort of non-conducive type, but at a higher threshold, and 43 was in relation to fraud or naturalisation. And the important point about 42 and the introduction of 42 was it was the first time a person who was born a British citizen could be deprived on such grounds. So it was a really significant development in the legal context of deprivation for the purpose of the non-conducive or types of case. So alongside that, there then came the right of appeal under section 40A, which was trailed there on page 52, and just so that it's very clear that the introduction of the SIAC appeal under 2B was also inserted by that provision. So that's the important point in relation to that. And we set.
Sorry to interrupt again. Is that
Yes.
the first reference to SIAC then?
I think that's right in the context of a right of appeal.
All right.
It says under 40A.
Because we have the SIAC Act, which was whenever it was.
Oh yes, 97. That was predominantly in relation to deportation appeals. This provision in 2B, a person may appeal to the SIAC against a decision to make an order under Section 40, where either under where there's been a certification under 42A. And I think that's important for these purposes to see, and the other, to see that that's where because of the change in the structure to the deprivation decisions, the rights of appeal were then inserted into the Act. And I'll pause there for a moment. I just wanted to take the court to one more provision here behind tab 3, which is that expressly, again in the 2002 Act, section 7, the previous requirement that there was no requirement to give reasons for discretionary decisions and no rights of appeal shall cease to have effect. So it was explicit there. We know that we've looked at the requirement to give reasons, and Mr. Kiriko, I think, took you that yesterday, but just to be clear where it comes from, it came from that provision. And the final point that I made.
Sorry to interrupt again. That was introduced then for the first time in 2002.
Yes. So the 2002 Act changed the structure of Section 40 decisions, introduced a right of appeal to the tribunal or SIAC, depending on where we were, and thought it necessary to actually express that the previous provision, that there was no requirement to give reasons for a discretionary decision and that there was no right of appeal, ceased to have effect. So it might have been said that it wasn't necessary, but in fact Parliament saw fit to do that there. And I've also included, you don't need to turn those up, the explanatory notes behind tab 1 at pages 3 and 4, just for completeness, if the court needed to see those. And the only other point I wanted to make, I think Ms. Smythe took you to, was that until the 2014 Act, all of the and from 2006 certainly at the time of Delhi Alisi, which is the point I uncovered just by preparing this bundle. So behind tab 5, the court can see that when under the 40A appeal, there was a provision that was removed by the 2014 Act that under 40A subsection 3, section 87, successful appeal direction, for which purpose a direction may in particular provide for an order under section 40 to be treated as having no effect. So it gave a power to the tribunal when determining an appeal to make an order of that nature. And the problem that, as the court will see, is that Parliament amended section 82 and onwards without, we would say, but anyway, just in passing, without really a regard for what the consequential impact was on, for example, deprivation appeals, because it's not clear that it was intended that the tribunal hearing a deprivation appeal would have no would have no power to make a direction. The reason those directions went was because of why the 82 appeals had changed, and my lord, I think, observed this. My lord, the Vice President, observed this in the Chowdhury case last week. So it was just for the sake of completeness, so the court could see the evolution of the rights of appeal.
Well, thank you very much.
Can I just ask one further question? Sorry to be a pest on this. When did the section 45B, which is you've got to give reasons, come in? We can see that it went out negatively in the bit you've just taken us to.
So the direction, yes, that was the 40.
Well, okay.
Sorry, was that 40?
Just thinking aloud, that must have come in at the same. The two must have been simultaneous, mustn't they? Because 45, including therefore 45B, comes in about
2002.
In 2002. Yes.
Yes. So, and the only thing that really changed, I hesitated to give the court anything else, and I haven't, but the only thing that changed of any significance was that in 2006, to present day, the non-conclusive grounds were introduced. So it went from seriously prejudicial to non-conclusive, and that under 42, and that changed in 2006. So I can hand up the relevant.
Well, was the language change? I wasn't
language
aware
changed,
of that, yeah.
and it changed very significantly. Perhaps I could just hand those three up. I think I did mention.
All
that
right,
last
but we've got plenty to deal with here without dealing with 42. But still.
yes, well, when the court, because we've got a joint authorities bundle in Chowdhury, with Chowdhury, and because the court heard the colloquy, these issues came up, I think, in Chowdhury first of all. It was just to be clear as to why there is a right of appeal, against what decision, and what's the statutory context.
Thank you very much.
I think I'm just giving away all my copies, but I know what it says. So that's just so that the court, when examining the role of the appeal, can see the significance of what was originally the decision under appeal, how that has changed, and because Mr. Blundell's submissions in Chowdhury focused on emphasising the language of is satisfied in 42 and 43. I do note, however, that Miss McGarhy yesterday in colloquy conceded, as I heard it, but I'm sure that until I'm wrong, I am, that under section 44, 40, open brackets 4, that the question is satisfied as to statelessness is a question of fact and law for the tribunal to decide, and that if it is decided, it's not a discretion, it's a mandatory requirement. The Secretary of State may not deprive somebody where they are stateless. So although we're being told by the Secretary of State in different counsel in different appeals that the language is very important, and therefore you have to read them all in the same way, the decisions under appeal start differently, evolve with different language, and Miss Smythe, I think it was in Shitey, said that section 44 was sui generis, or submitted that it was. So Miss Smythe says it's sui generis, Miss McGarhy says it actually should say must, not may, and it's a question of fact and law for the tribunal. So we are in and we now hear from Mr. Blundell in Chowdhury that this tribunal, and in this case, can make findings of fact. So the Secretary of State's position is hard to pin down in some ways, but I have to try to now make sense of what that means for this respondent. But I do think it's important that the court has that breadth of understanding in relation to the
very well.
framework.
Thank you
So
for all that
that's-
hard
so-
work that went into that bundle.
So hopefully that's where we leave that, but I just wanted to put that there. So I just wanted to summarise. The court has seen, and Miss Smythe has taken the court to the decision making in this case. The Secretary of State issued a notice. The respondent solicitors replied in some length in those representations, and then the Secretary of State reached her decision. It's fair to say that the representations didn't, in terms, address the policy and the framework of the minority status, but those were matters that were then raised before the First-tier Tribunal and the Upper Tribunal. And if it does assist, and I don't want to give the court any more paper, if it did assist, we've got the skeleton argument, certainly, that before the First-tier Tribunal, where this is set out in great detail. Importantly, one of the factors that was put before the Secretary of State in the representations was the fact that he was a child in care in the care of social services, and he remained in the care of social services until he was 21. That's just for the court's reference. It's page, you don't need to turn it up, page 109 of the supplementary hearing bundle. We place in the care of Lewisham Social Services. So that's a particular factor in relation to the way in which the representations were put. But can I take the court? This is how the case is put before the first tier and the upper tribunals, and the key factors that we say are relevant to the decision-making process, which is the Secretary of State's policy, and that is to be found in the supplementary bundle at tab 15. We did set this out for our open argument, but I'm not sure that it's the import of it to quite. What needs to look at the policy, because Miss Smythe is referring to the policy and the way in which that is considered by the Secretary in the decision letter as demonstrating that there's no public law error in relation to the approach. So at page 153, that's the beginning of the substantive part 1 deprivation, 55.2.1. I don't know whether I should take this. I just noticed the time. Apologies. I wonder whether we should just come back to that at. Sorry, my watch said 59. I don't know if that clock is slow, but I'm happy.
So does my computer.
Yes, well.
Very well. We'll sit again at 2.